it's been a very positive thing, and I think that it's been good for the public, although on occasion I've made some mistakes, and I fess up and I apologize. But I get the range of questions that I wrote a letter to the mayor of the city of Spokane, because back this summer, the city of Spokane raised its copying fee for public records from 15 cents to 50 cents. And there were a lot of complaints. And you may think, well, why does the Attorney General care about the copying fee for the city of Spokane? Well, 50 cents may not be a lot to you per page for a public record, but for some people, it makes the difference between being able to get access to public records and not being able to get access to public records. So I wrote a letter to the mayor of the city of Spokane, and I politely questioned how they arrived at their calculation of 50 cents a page. And I pointed out that Kinko's can copy paper pages for about less than 6 cents a page. And I politely encouraged them to revisit it. Well, it turns out that the city of Spokane had calculated their copying fee based upon the salary of one of their individuals making copies, and they didn't take the salary of the lowest employee who would be assigned this duty. They took the salary of a middle range employee who was earning approximately $46,000 in salary, not including benefits. And that's how they came up with their 50 cents a page charge. Well, to their credit, the mayor and the city revisited their policy and reset their copying fee charge. But these are some of the small things that I do, and sometimes I can have a positive outcome and help people, but not always, because as Toby said, I don't have enforcement power. But I find that I don't always need enforcement power. You know, the power of the pen, being able to write a letter to a city mayor or a county or a government agency on the letterhead of the Attorney General really does make a difference. I wrote a letter to the city of Olympia because they had a complaint. Citizens were attending the public meetings of the city of Olympia. And during the public comment portion of those public meetings, people would come up to the podium to talk to the city council. And the city council members had their heads down. They were typing on their computers. And it appeared to the citizens that they were not paying attention to anything that was being said. And so one of the citizens who was making a public comment thought it was pretty rude and decided to make a public records request for the emails that were being sent from the city computers during these public meetings. And there was no exemption for these emails. They were disclosed. It was very apparent that the council members were emailing each other about agenda items that were being discussed during the public meeting. And they were making substantive discussions in some cases. Should we table this motion? Should we go forward? And it was almost as if they were having a private meeting within a public meeting. Once this came out, I did write a letter to the city and I said, hey, I don't think this is in accordance with the spirit of the Public Meetings Act, and please revisit your email policy during public meetings. And to their credit, they did, and they put it before a committee, and they came up with a new policy that restricts the emails. But I think that some of this is a matter of education. Currently, under the Public Records Act, there is no training that is required. So if there is training that is attended by city council members or by designated employees of a city or a county, that's a very good thing. That will avoid numerous lawsuits, that will avoid confusion, that will avoid misperception. The Attorney General's office provides some of that training. I do it. I go around the state. I provide a PowerPoint presentation. Toby Nixon does a great job on training. It's an ounce of prevention. It's fantastic, and there's a lot of questions that I get during this training about all kinds of issues. But ultimately, the Attorney General decided that it wasn't enough just to have an ombudsman that answers questions, and he has been assertive in trying to reform the Public Records Act, bring it up to date, and to improve it in areas of its weakness, and he has had a legislative agenda each session with some suggestions to improve both the Public Meetings Act and the Public Records Act. And recently he created a task force, an open government task force, And it was jointly sponsored by both the Attorney General Rob McKenna and the State Auditor Brian Sontag. Ruth Gordon was a member of this task force. Toby Nixon was a member of this task force. And what we were discussing and studying was, is there a better way to enforce the Public Records Act and the Public Meetings Act without a whole lot of litigation and cost? Because whenever there's litigation and a government agency has to pay their attorney fees, those are monies that are really tax dollars that you and I pay. So we're trying to improve disclosure, reduce litigation, and we looked at some other states, particularly Pennsylvania. Pennsylvania has an administrative agency. It's an administrative board where for a very minimal filing fee, you can have an administrative law judge resolve a dispute in a very quick period of time. I think it was 30 days or less. You'll get an answer as to whether you can get access to a public record, and there isn't the threat of attorney fees and costs and penalties hanging over your head. And so this task force had 2 meetings. We studied the issue, and we came up with some recommendations that the state of Washington should create a similar administrative agency that enforces the Public Records Act and the Public Meetings Act. As Toby described, currently no board exists. The only way to enforce the Public Records Act is to file a lawsuit. Same with the Public Meetings Act is to file a lawsuit. So a lot of people are turned away because they just can't afford an attorney, or they don't want to go through the expensive public process of a lawsuit anyhow. And I understand that. But there are a lot of cities and counties and local agencies that don't want to get dragged into court. It's expensive, it's time consuming, it could be potentially embarrassing, and there's got to be a better way to do this. So we'll be running some proposed legislation this year, and we haven't introduced it yet, but we'll do it very shortly, that would create some kind of state administrative agency to enforce the Public Records Act or the Public Meetings Act. I think it's very, very important to improve access to public records and public meetings. And it seems somewhat of an uphill battle from time to time. But it's not a partisan issue. It's never been a partisan issue. It's been a nonpartisan issue. It's not a Republican versus Democratic thing. Generally it's citizens who want access to public records and public meetings, and that's fine. The Attorney General did adopt some model rules, which are best practices to provide some guidance, but we need something more than that. We need some kind of administrative adjudication.